So far, we've looked at mistake and we've looked at duress in terms of problems around consent. The third area where we're going to look at is undue influence. Now, what undue influence requires is a person who is in a special relationship with another who has influence over their decision making, and then they take advantage of that relationship to strike what is essentially an unfair bargain, or a bargain that shouldn't occur. When we talk about the bargain not occurring, we're saying they're overtaking the other person's independent judgment. You can see here that there's a series of relationships where people have significant influence over others. So we can see doctor-patient, lawyer-client, parent or guardian and child, religious leader and follower. These are all relationships associated with a strong degree of influence over the other. And in these situations, the person who has that influence, so the doctor or the lawyer or the religious leader, is the one that must show that they didn't exercise undue influence if there ever is a problem around a contract. You know, the truth is you probably shouldn't be entering into contracts with those people, and if you do, you need a third party involved to make sure that there is no undue influence. So the key factor here, though, is that the onus of proof lies on the influencer, the person with the power, to show that they didn't exercise that power unfairly and have undue influence. In contrast, there are similar but not quite as influential relationships, things like spouses, accountants and clients, etc., where we don't necessarily assume that they had that undue influence. It's then up to the party who is arguing that they were influenced to actually show that that party did have that influence. Once they establish that, though, then they have to show that once they establish that that person did have influence on them, then again we get into the situation where that person has to demonstrate that they didn't use that influence unfairly to overrun the independent judgment of the other party that they were contracting with. And that's important, right? Because what we're dealing with here at its heart is the issue of consent. And consent requires the exercise of the independent will and judgment of the individual. If that's overridden because you are subject to influence of another party, then we can't have agreement. And that's what this is really all about, where you wouldn't have exercised your decision the way that you did, except for the influence that that person had over you. So that's undue influence. Unconscionability is similar but different. At the heart of unconscionability is a person's special disadvantage or weakness. So rather than being based upon a relationship where you can influence someone, which is undue influence, unconscionability arises where one party has a special weakness or disadvantage, the other party knows about it and takes advantage of it to create an unconscionable or an unfair bargain. So rather than the relationship of influence being central, here we're dealing with the disadvantage or the significant weakness of another that the other party knew about and took advantage of. One of the most famous cases surrounding this is the Commercial Bank of Australia and Amadio. In this, we have a husband and wife, Mr. and Mrs. Amadio, and so we get the husband and the wife. And it all has to do with their son's business. So we have the husband and wife, and we have the son. On the other end of the transaction, we have, of course, the Commercial Bank of Australia. So we've got the bank. So we got the parents, we got the son, and we got the bank. Now, the son was running a business, and the parents, they thought, so we probably should put a thought bubble up here, that they thought that the son's business was successful, and they also were under the belief that if they went as guarantors for the son's loan, that it would be limited to a certain amount. I think it was $50,000. So what happened is that the CBA, the Commercial Bank of Australia, enticed them to guarantee the son's business loan. Guarantee son's loan with a mortgage. So essentially, they put their house on the line for their son's business. They were under the belief that the son's business was successful, and they thought that the most that they would ever owe was $50,000. Now, some other factors that were really important were how old they were, that they were immigrants, so that they didn't understand English very well, and that they had no idea of their son's business. So we have three particular elements here looking at the disadvantage of the parents who are guaranteeing the son's loan. And when the CBA took the loan agreements, so loan agreement here, and they gave the money to the son under the loan, and we have the guarantee up here, so that if the son can't pay it back, the parents have to. When they took the loan agreement to the Amadios, the bank manager didn't explain it. And what the court decided here was that the mortgage and guarantee were void. So the mortgage and the guarantee were void. They said this was an unconscionable bargain. They said it was unconscionable of the bank when they knew that the Amadios couldn't understand English, that they had no idea of their son's business, while the bank did, and knew that it wasn't going well. And considering that they were old as well, it was unconscionable of the bank to not explain that to them as part of the transaction. The bank knew about the special disadvantage and should have done something to ensure that they were better informed. And so because of that, we have unconscionable conduct, an unfair bargain, and the court ruled it to be void. You can see that the issue there is not so much a relationship of influence, but rather the conduct and taking advantage of someone. What will be necessary to show a special disadvantage? Well, it's going to vary by case, but there are some things that you might want to look at. They include sickness, illiteracy, maybe a lack of education. Really interestingly though, even being in love can be considered a special weakness or disadvantage, as I'm sure we're all well aware. So here we have the case of Louth and Diprose. Diprose is a solicitor and Louth is the client. The solicitor is a twice divorced, middle-aged gentleman who becomes infatuated and emotionally dependent on Louth. Louth says she and her two children are about to be evicted from their home, and in doing so she induces Diprose to give her $60,000 to buy a house. He later tries to get that $60,000 back, and the court actually found Louth had acted unconscionably, essentially by preying on Diprose. The court found that Diprose's unrequited love for Louth had put him at a special disadvantage that Louth had unconscionably exploited. She'd exploited Diprose's love for her to benefit herself. So I think you'd agree that there's a wide series of circumstances which can meet those conditions for a special disadvantage or weakness that the other person takes advantage of. With unconscionability, we're going to come back to it when we do consumer law. Most of the areas around unconscionability and around undue influence, look, they're often incorporated into consumer law, which we're going to do more of in week 10.